Part 10 is removing the right of detention. So the topics are: the time starts from when you are not free to leave. First check and balance if arrested is the handover to the custody officer. Conditions when detention must be ended. Claims to continue detention to affirm your name and address. Claims to continue detention to prove or disapprove your involvement. Claims to continue detention to secure or preserve evidence. Legal representation. At the interview. Use your time constructively if detained, i.e. learn your rights. Get your discharge and detention records before you leave. Report on lawful use of force and get a crime reference. Report to the IPCC if they refuse to give a crime reference number. Follow up the investigation report to the IPC if no action, and take to court if no further action is taken by the police. And there is quite a fair amount of further resources for people to look at on this point.
Yeah, so basically, like you've seen, it's always the same steps, and what you'll see is what we've been saying previously. This question, am I free to leave, is actually a very important question. So the other thing is, the time starts from when you first ask that question and they show any action or words that you are not free to leave. So what's come to our attention is that they believe the time starts when you hand it over to the custody officer. That is incorrect. It's when your detention starts, when you're not free to leave. So that's extremely important. So the first check and balance then of is your arrest being lawful is when you get handed over to the custody officer. They must carry out what's called one of two tests, either the full code or threshold test. And that is based upon the evidence at the time. So this needs to be done as soon as possible, and in any event no more than 6 hours after the arrest. The custody officer must at all times release anyone if the grounds of arrest no longer do apply. So they have no lawful excuse, that's when you must be released. So to affirm your name, we've said we can provide our name to avoid being arrested, but that does not mean they will not arrest us anyway, but you simply respond, prior to my arrest I've already given you my name and address, so you can lawfully serve me any claims you may believe you have against me, to which I will respond accordingly, thereby making this arrest unlawful. Any legal claim you may believe you have is order following, which is not lawful excuse under the binding precedent, common law precedents of the Commissioner of Police of the Metropolis versus Razi. I'm innocent until proven guilty, and as claimant you must prove your claim. Guilt is determined by the courts and not you. Am I free to leave? So you're reaffirming you've already given them the name. It's an admission though that the arrest is unlawful. If they'd used any force, that's been unlawful, and your detention has been unlawful, and any further detention is unlawful. So they look for other excuses, and they use legal excuses. The main ones being that I've come across is detention without charge is necessary in order to prove or disprove your involvement in the offence by means of an interview. What is this? Again, it's an admission of unlawful detention, because to have instigated the arrest, to have breached your peace, they must have the evidence at the time. They cannot collect it afterwards, to which you respond. You've now admitted my arrest, and hence my detention is unlawful. As you still fail to have lawful excuse to breach my peace under the binding common law precedents of R versus Howe. Your legal claim is order following is not lawful excuse under the binding common law precedents of the Commissioner of Police of the Metropolis versus Razi. Lawfully, by your admission, you must immediately release me. You have my name and address and can lawfully serve me any claim you may believe you have against me, to which I will respond accordingly. I'm innocent until proven guilty, and as claimant you must prove your claim. Guilt is determined by the courts and not by you. Am I free to leave? The next excuse they say is to secure evidence. again, this is an admission their actions have been unlawful up till then, as they should have had this at the time. So this one you deal with slightly differently. You first ask them, please state what evidence you believe you must secure or is in my possession. So they've made the claim they must secure evidence, so you're asking them now, tell me specifically. Because obviously if they cannot tell you specifically what they're looking for, they do not have lawful excuse. They actually don't even have legal excuse then either. Again, if they cannot, hence we say you've now admitted my arrest and hence this detention is unlawful, as you still fail to have lawful excuse to breach my peace under the binding common law precedents R versus L. Your legal claim is order following, which is not lawful excuse under the binding common law precedents of Commissioner of Police of the Metropolis versus Razi. Lawfully, by your admissions, you must immediately release me. You have my name and address and can lawfully serve me any claim you may believe you have against me, to which I will respond accordingly. I'm innocent until proven guilty, and as claimant you must prove your claim. Guilt is determined by the courts, and not you. Am I free to leave? So again, every step of the way, we're standing on our rights. We're telling them that their actions are unlawful, why they're unlawful. So, doesn't mean they're going to let you go, but as we know from all of the others, we need to create our record. But should they insist on wanting to interview, the question of legal representation comes up. Now, if you say yes, you want legal representation, what have you done? You've made a request. They will comply with your request and detain you until legal representation comes along. So, we deal with this in the following manner. You simply say, I do not want legal representation and insist you interview me now. So, if they do not release you and start the interview, you reinforce, you say, I've already stated I don't want legal representation, but I am present. So you can interview me now without further delay and where I stand, and where I will stand on my right to remain silent. You have my name and address, and where you can lawfully send any questions in writing to which I will respond accordingly. So now what we're saying is, okay, any questions you've got, give them to me in writing, you've got my name and address. Same then, I'm innocent until proven guilty. As claimant, you must prove your claim. The courts determine guilt, not you. Am I free to leave? So if they continue on to the interview, now what's important, you've got a professional there who knows how to trip you up and draw information from you. And this is why the previous statement was important. You have my name and address, you can serve me any questions you want there. So what you're trying to do is remove yourself from the pressure of the situation where you can think clearly. And what they do tell you is you do not have to say anything. So if you're saying no comment, that's the worst thing you can do. I know many people advocate saying no comment and don't speak to the police. And the reason it's the worst thing that you can do is it may harm your defense if you do not mention when questioned something which you later may rely upon in court. So they're telling you about this. And that there's basically, because under the rules of equity, you could have sorted it out earlier and did not need to go to court. Hence, instead of saying no comment, you say, I stand on my right to remain silent. You have my name and address where you can send any questions in writing to which I will respond accordingly. I'm innocent until proven guilty, and as claimant you must prove your claim. Guilt is determined by the courts and not you. Am I free to leave? So you see how with the wording we're just removing ourselves from this threatening, intimidating environment.
It sounds like the same statement, but it isn't. Saying no comment is not saying the same as I stand under my right to remain silent. What you're doing is, again, you're enforcing the fact that you understand your rights.
Yeah.
And
you're saying, I'm happy to answer your questions, but I'll do it in my time, in my comfort.
Put them to me in writing.
Put them to me in writing.
An interesting point here, we've heard a number of people over the course of certainly recent months saying that any form of interaction with the police, do not give your name and address. That's exactly why you should give it.
Absolutely.
Because what you're saying is, here's my name, here's my address. So anything that you think you've got against me, you can write to me there.
Absolutely.
Because if you're in a scenario whereby the police felt that you were breaching the peace and they were going to arrest you, they're going to arrest you whether you give your name and address or not.
However,
So
if
you
you
may
do,
as well give it.
No, but if you do, you've removed that lawful right for them to arrest you.
Correct.
Now they've acted unlawfully if they do arrest you. So it's all step by step. And remember, we can lay claims against one another, but it's the court that determines guilt. So long as they have your name and address, that's it. They need nothing else. They can serve their claims through the courts.
Yeah.
Now going back to this, am I free to leave? The Police and Criminal Evidence Act 1984 makes it very clear that the first, what they call a detention review, we said when you hand it over to the custody officer, they must do a review of the lawfulness of the arrest by evaluating the evidence at the time, and if they no longer have lawful excuse, they must release you. That's the obligation of the custody officer. So within 6 hours of you being arrested, they should do the first review. They need to do a second review within 9 hours of the first review, and the third review they must do within 9 hours of the second review. Now, if they continue your detention, they must explain the reasons to you. And that's where they go to those questions. Oh, it's to make an efficient investigation, it's to secure evidence, it's to interview you, etc., etc. And we've already looked at how you can remove that as lawful excuse. And they can detain you for a maximum of 24 hours from your arrest. The police don't understand this, and many people are held 24 hours from when they arrive at the station. The superintendent or a higher ranking officer can extend this to a maximum of 36 hours, and beyond 36 hours it must be done through the magistrate's court. Once they discharge you, the custody officer must give you either a charge sheet or a notice of not intending to prosecute unless new evidence comes to light. Now, that notice is exactly the same process what we've been pushing and saying at each step of the game. Where's your evidence? Where's your evidence? Where's your evidence? Because every time they don't have it, they are acting more and more unlawfully. And further, your custody record and detention record, you must insist upon getting at the time of your discharge. They will tell you, oh no, you can't get it. It's a legal obligation. And I said, if you detained, use your time wisely. And what they should do, when you arrive in custody, they will say, you've got, here is your rights whilst you're in detention. And you can learn all of these things through there. So, including the record must be given to you. They will be very reluctant, because certainly at many of these meeting of the minds, demonstrations, whatever you want to call them, remember it's a petition for your rights to the monarch. However you express them is fine, up to you. But with that, you standing on your rights, you need the paperwork to be able to stand on the rights. So once you've got all this paperwork, again, create the record, report any of the crimes, if there are any crimes to the police station, follow it up. If they've done nothing, report it to the IPCC, and that way you've got the record which you can take into a court that you've done your pre-action protocol, and we can start to hold these people to account. It's all unlawful people, the actions we need to start holding people to account.
Yeah.
So that sort of covers the common elements, and they use threats and intimidation all the way through, which we've seen at many of the protests and things like that. So we've got rights, we've got to learn to stand on them. But like we saw, the monarch's promise is to govern us according to our respective laws and customs. The laws, I've given the laws in here which define how these things should operate and what rights you have. So it's time to change our customs to hold people to account for their unlawful behaviour. And it does not matter if it's a public official or anybody else. So I think that covers it.
And I think that pretty much concludes
Modules.
training module number 2.
Yeah.